Well, hello, everyone. Good morning. So, obviously, I am Judge Sancerni. I am in the Orlando District. And I have today the esteemed panel of claimants attorneys here. I have Diana Castrillon. Diana started her practice as a defense attorney representing insurance companies, and for the last 20 years has been representing only injured workers and workers' comp cases in South Florida. I have Mr. Ehrlich. Ken Ehrlich leads a personal injury and workers' compensation practice in the Treasure Coast area, because of course he's very precious to everyone. He is also a Florida Supreme Court certified civil mediator. And last but not least, I have Amie DeGuzman, who over the last 9 years, Amie has represented injured workers and first responders at both the trial and appellate levels. She practices in Jacksonville, Florida. Please welcome our panel. As indicated by Judge Hedler, we are doing a claimant's perspective of workers' compensation. And we have several topics that we wanted to discuss. More this way. We have several topics we would like to discuss. And when I was discussing it with the panel, you know, I have an employer carrier's perspective because that's what I did for 20 years. So I always like to talk to claimants attorneys and find out how the practice even works. So in discussing that, we started with discussing about statute of limitations. And so in talking with that, I was speaking to Amie, and I said, so you sign up a new client, Amie. So do you first analyze your case and try to ascertain the statute of limitations under 440.19? And are you looking at the 2 years, 1 year? Can you give us some perspective on that?
Yeah, so that happens a lot, especially representing first responders who come in. We do look at the statute of limitations pretty much right away based on their date of accident. And when we do that right now, what we've been doing is starting with an Ortiz chart, an Excel spreadsheet with...
Yes, she said Ortiz chart. She has charts for lots of things.
And a degree in Marvel movies with the alternate universe.
And it, you know, has date of accident, first provision of benefits, last provision of benefits if there is one, and the dates, and then the countdown clock by formula. So I know right away whether or not that's going to be an issue. And then, you know, if we've passed that test, we do also look at the 1 year just so we know, but that's usually in the chart.
Now, some would say that the Ortiz opinion, the statute of limitations never runs. Do you agree with that statement?
No. I had a gentleman who, and I'm going to change all the info because, but I had a gentleman who came to me, and his accident happened in 18, treated till 19, and came to me. We did the Ortiz chart, and his last treatment was, I want to say, at the beginning of 2020-ish, and he came to me 2 months after what would have been the 7/30 date. And so for him, there was no avenue to bring any more, you know, bring a claim at all for him.
Is there any recommendations you would make as a perspective from the claimant's bar in regards to the Ortiz case being also the mandate has been withdrawn? This is why she's the appellate side.
No. You know, obviously, as a claimant lawyer, we appreciate the court's interpretation of the 1994 change in the statute, recognizing that it created 2 subsections. And so knowing that that change occurred and having it interpreted in Ortiz, you know, of course, we appreciate that there's 2 separate timers. As far as the mandate issue goes, it's my position that just because the mandate's been recalled, it doesn't change the binding nature of the case, and that comes from a couple of different sources. I don't necessarily want to bore everyone with case law, but one of which is Cray versus State, which is from this court in 2014, and it cites both Padovano's Florida Appellate Practice Procedure, Section 207, as well as Rock versus State and Henderson versus State. And Henderson versus State is the Florida Supreme Court. And the case basically says unfortunately for this gentleman, it was a felon with a firearm, and he agreed to certain facts that resulted in the opinion being affirmed. However, the position that a case didn't apply to him because it was on rehearing still pending, the court said that that was not the position. It was still applied, even though it was still on rehearing, but it was affirmed because he made some factual concessions in his position. So from the claimant perspective, for me, it is still binding. I'm sure there are those who disagree.
So in English, we should still follow Ortiz until something else comes along.
And in that, with both you, Ken and Diana, do you see even the defense bar now throwing the Ortiz back at you and say, well, the mandate's been withdrawn and therefore the statute has run on a specific case? Are you seeing that?
To some degree, yes, but I'm following Amy's lead because she's much smarter than the rest of us.
And that leads us into, there's been a lot of oral arguments on statute of limitations recently. So recently this week, actually, there was a Stewart case that the first DCA affirmed, and they just cited the Moisey case. The employer cares would suggest that claimants' attorneys have a long time practice of filing notice of voluntary dismissals, notice of resolutions, with reservation on attorney's fees and costs as a tactic to prevent the statute of limitations from ever running. Do any of you feel that the Stewart case impacts that practice? And if so, how?
I think Stewart follows previous case law, so I don't necessarily feel that the PCA with the cite to Moise has made any sweeping changes. It's not my practice to reserve unless I am owed a fee. I'll waive if I know that the benefit's been provided within 30 days on fees, not necessarily cost, but on fees. I think that's appropriate. So, for my practice, the decision doesn't make any substantive change on what I'm going to do.
And in my practice, I just see defense attorneys moving to compel verified petitions if there's any question of any doubt, and we'll answer them, we'll file our verifieds, and we'll deal with it. So.
Anything from you, Janet?
No, that kind of covers it. I don't see a big change. I think if you're doing things for the right reasons, then none of these cases should impact your practice. Obviously, if I'm reserving on fees, it's because I feel that there's entitlement. I'm not doing it for some sort of tactic or strategy. And I think the lion's share of claimants' attorneys would share in what I'm saying and agree with that and probably practice that way. But of course, there's always going to be a few bad apples that will taint our practice. But I don't take reservation of fees from a tactical perspective. It's a, I believe I have entitlement perspective.
And so once you've determined on your client's case that the viability is there because the statute hasn't run, is it your practice, Diana, then to start looking at an analysis to ascertain if the injuries arose out of employment?
Yeah, so the rising out of, right, that became the fun new term for workers' compensation practitioners. Not new, it's always been there, but now we talk about it a lot more. And so I when I talked about this before and when we were speaking about it in preparation, my thing when I first started practicing 24 years ago is I would always tell clients when they came in my door, the great thing about workers' compensation is that even if you trip on your own shoelaces, as long as you're in the course and scope, you're going to be covered. That was like it's still part of my spiel. But now I hesitate a bit in thinking that way. And that comes from a lot of the newer cases that we're seeing with regards to arising out of. And so I know we're going to talk about some of those more particularly. I don't know if we're talking about those quite yet. And I don't want to go out of order, but obviously there's been a tremendous variation in the tripping over shoelace type cases, because now it's, well, where were you standing when you tripped over those shoelaces, and should you have had a different type of shoelace on, and coefficient of friction. So we're in a whole different world, y'all. And so it's definitely an interesting part of our practices now, and I know we're going to delve into that a bit more, so
I was going to say that's a good flow into what are the challenges you're finding when you're dealing with the cases like the Bouillard, the Valcourt, the Silverberg.
So yeah, I mean, obviously there's the Valcourt-Williams case. We all know that. That really is what started this conversation. I think a lot of us thought that was a one-off, and that was just right? Yeah, thank you for one of you guys nodding. I really appreciate that. Whew, I thought nobody was listening. Just kidding. So yeah, I think that was what we thought was a one-off. It was a really specific set of circumstances. I always call Valcourt-Williams the, gosh, why'd you say it was a dog case that you tripped over? So, but obviously teasingly, but the idea is that it seemed like a really specific and unique set of circumstances. It was the working from home world that was kind of newish, and it was just, oh, this is just that weird thing. But we all know from what I call the Valcourt-Williams progeny of cases that was not a one-off, and it still continues to be a very big conversation piece. So obviously we went into Soya, we went to Silverberg, and we've continued now into Bouillard in a recent case of mine that was PCA'd without an opinion, but it's all on this exact question. We're still chipping away at, from claimant's perspective, we're still chipping away at coverage for individuals. And it becomes a lot more of a practical concern for me as an attorney when I'm signing up a case and a person comes in and relates to me what I feel has always been established law is a covered event. And now I'm going, wait, is it?
Yeah, that's the problem. The law is becoming a moving target, and it's more in line with sort of ERISA cases, where it seems like every month the law shifts from here to here to here, or you're importing liability into a no-fault system, and it's becoming more and more complex, and we have to evaluate these various factors, and it literally almost becomes a personal injury case as opposed to a workers' comp case, because you're dealing with all of these fault-based circumstances which really frankly have no business in comp, because the whole purpose of comp is to make it a no-fault system so you have an efficient delivery of benefits, as opposed to the negligence type situation where you're proving fault, but you also get the compendium of personal injury type damages, negligence-based damages, which we don't get in comp. So it seems like the law is shifting, at least from a claimant's perspective, from here's our simple no-fault system, here's our way to provide expedited benefits to an injured worker and ideally get them back to work as fast as possible, to we're going to import all of these components of fault into this system, make it like a personal injury case, but we're going to deny the claimant the personal injury type damages that you get for having to jump through all these extra hoops and prove fault. And frankly, another perspective of it is it opens up employers to liability suits. There's a large component of these things that eventually are going to shift from, hey, I'm covered under comp, to Mr. or Ms. Employer, I'm going to sue your ass for negligence because we've written you out of workers' comp and you're exposing that employer to a whole lot of hurt that they shouldn't be exposed to because they purchased a workers' comp policy. So I think that direction is kind of scary. It also may ultimately erode on the grand bargain, but that's just, again, my perspective of life.
Well, Ken, in light of that, seeing that you're having to review so much more and get into so much more in depth, how has that changed even your practice when you meet with your clients?
Oh, it's definitely impacted our practice because, we spend, at least the three of us spend a lot of time in an initial consultation meeting with clients, and we're going over these things. So what used to take an hour now takes 3 hours. And claimants aren't exactly on board with, hey, can I take your deposition for 3 hours just to figure out if there's a viable claim or where the direction of things are going. In our TikTok world, frankly, injured workers are like, come on, let's go, sign me up. They see the TV commercials, sign me up, let's roll, let's roll, let's roll. And we've got to slow it down, and it's definitely impacted the way that we practice because it's much harder. We have to screen things in advance. We have to start contemplating, okay, are we going to need basically a liability type expert on this case from the get-go? Are we going to have to send out preservation of evidence letters to preserve videos? Are we going to have to start scheduling depositions next week? Are we going to have to do all these things that in the ordinary course of a workers' compensation case, you don't necessarily need all these things, but now we do. So it makes the intake process much more complex. It makes evaluating a case much more complex because to quote one of the cases, we're importing an additional contingency fee risk into our practice that wasn't there before.
Do you find the same challenges, and this can be to all three of you, with discovery? I mean, I always hear rocket docket. Everybody loves to say that. Do you find those challenges now?
I find those challenges every day. So what's happening in the workers' comp world, especially in getting depositions set, in getting discovery responses. I'm not going to poke at the defense bar, but there's a lot of delay in the process of getting depositions set. And so what I do appreciate, at least in our geographic region, is being able to file motions to compel, being able to get these things set for motion hearings and live motion hearings or Zoom motion hearings, because I find that that's an extremely effective tool in allowing us to get past all the smoke and mirrors and all the obstructionist crap that we have to deal with, so we can get our depots set, we can get our discovery. And I think that's been a very effective tool. So I think Judge Hedler has done, and his team have done a tremendous job with getting that motion practice going. I know, Judge, you do it as well. And it really forces the parties to sit down and oh, this isn't like federal court anymore. It's like the good old days where we could sit down and talk, where we have to deal with opposing counsel, because it's a lot easier to write a motion or write something on paper and go, yeah, you know, I just wrote this badass response. And the judge looks at it and rules, and we don't get to put the full color. More importantly, we don't have to talk to each other. When we're face to face, a lot of times that forces resolution. Hey, I don't want to go in front of Judge Sancerni today because she's going to rip me a new one for this.
Possibly.
So I think that's a really effective tool in helping us move our files, because quite honestly, there's no other practice that has to move their files as fast as we as workers' compensation practitioners do. So I think it's extremely difficult to get depositions in. I'll give you an example. I was in circuit court the other day on a motion hearing from a motion that was filed 7 months ago. And we get there and the judge goes, yeah, I don't want to hear this. This needs to be set on my special set calendar 6 months from now. So give credit to the JCCs, because I think this is an effective tool to move our files and to help us get the discovery we need going up against this rocket docket that we call the 210-day rule.
Yeah, it seems like in the world of technology and the keyboard warriors of the world that we all know exist, you know, in a larger perspective, you know, we see that in our practice. Obviously, it's really easy to write an angry email. It's really easy to write an angry response, but it's definitely different when you're sitting down and talking to the person, because look, there's a lot of stuff going on in people's lives every day. We know that, you know. So how great was it when we would all be at the division and we'd be waiting on motion calendar, and we would just be like, hey, how are the kids? Oh, you know, did your son get into that program he wanted to get into? You know, and you're sharing these moments with people. You have the human aspect that we are losing by not having that motion calendar existing anymore. The written response concept brings us into a very different federal court-esque world that we operate in. And so I guess this isn't necessarily a gripe session, although that's Ken's job here on the panel today. He's here for that purpose only, so don't judge him. But the idea is, you know, what do we take from these challenges that we're facing as claimants attorneys, and what tools have been effective for us in facing these undeniable challenges that we have as claimants and claimants attorneys.
And I have another gripe.
What's your other gripe?
My next
There's
gripe,
more later.
There's more.
There'll always be
But
gripes.
wait, there's more. So my other gripe is this, and it deals with motions in limine, and it deals with some of the discovery aspects of the case. Obviously, we in workers' compensation we have bench trials. And my concern has always been, and I don't know that there's necessarily a mechanism for this, and I think it's important that maybe we as the judiciary and the bar come up with a mechanism for this. So I have a motion in limine. My client is a 16-time pedophile, 30-time convicted felon, but it was all 20 years ago. And it comes out in his or her deposition, or there's an employer that's committed 33 layers of fraud, but it was done 15 years ago, and maybe it's not necessarily relevant to the issue of blood work that I'm fighting over. But it's going to come in a deposition, and why would we want that giant prejudicial evidence to come in? So we file a motion in limine with our trial judge and say, Judge, I don't want you to pay any bit of attention to this real nasty stuff that I'm trying to keep out.
About my client.
About my client. So let me just overemphasize it to you in a motion in limine and say, you know, here's some really bad crap that I don't want you to pay attention to. So,
I promise I will forget.
yeah, so don't think about the giant pink elephant that I'm going to mention to you, and I don't want you to remember the pink elephant, but that's basically what I'm doing. And so I think there needs to be a process within the districts in DOA so that you have a different judge deal with the motions in limine, so that your trial judge, who's now hearing this subliminally or otherwise, it may impact them, it may not, I presume it doesn't, but from an optics standpoint, why don't we have another judge in that district deal with these types of discovery motions in limine or motions to strike or motions to exclude, where we're dealing with prejudicial testimony or prejudicial evidence? I think that's important from both sides. I think it adds to the neutrality and it adds to the objectivity without prejudicing either client. And I'm not saying this just from a claimant standpoint, I'm saying this from a carrier standpoint as well. I think it's very important. And I don't know that our rules or our statute really has the direct mechanism, but I think that's an important paradigm that we should probably work to fashion a solution. And
I mean, I think from a practical perspective, I'm sorry to interrupt
No,
you,
go ahead.
Judge. You know, I think we can start asking for that in our motions from an immediate practical perspective. The bigger picture is some sort of rule-based resolution to this, but I think at this point, something we can do in our motions in limine is almost like a pre-motion in limine that says, and we would request an in-camera inspection or some sort of hearing to be held by another judge within our district or within the JCC, and I think you can ask for that in the motion. I know in speaking to Judge Sancerni, she says I would be very receptive to that, and I would, you know, hearken to think that most of our judges would feel the same way. So I think from a practical perspective, that's something the claimants bar can incorporate into their motions.
And I
now.
can understand that too, because sometimes, I mean, I'm not gonna harp on it. I probably will forget, to be honest with you. I'm amazed at this job, how much I have forgotten the first cases. That's come before me already. But I can understand and respect from both sides of the bar that you're representing a client, and you don't want that client to have the perspective or perception that I am holding that against them. So as, you know, that's why I indicated that to you guys. And that leads me into that communication. So what I'm hearing from you guys is requesting even live hearings. Sometimes, even if you don't get to the hearing, it's spawning communication with the other side. Is that what I'm hearing?
absolutely. I think there's, frankly, there's a lot of infighting that maybe shouldn't be there. And more importantly, I think from just a professionalism standpoint, if someone is setting a live hearing or a Zoom hearing, again, if I think my position is kind of tenuous, why the hell am I doing this? So I think it forces both sides to evaluate their positions, talk even more extensively than the pre-motion good faith communication. And I think a lot of this will resolve and things will move faster and more efficiently, because that's ultimately the name of the game. We, on behalf of the claimants bar, we want to get our cases to trial because I want my client to get benefits or have the opportunity to get benefits. And the longer that the carrier delays and denies, the worse it is for my client, both physically and financially. So I want to do everything I can to move this thing towards where it's supposed to get to, and, you know, obstructionist or just the speed bumps along the way that seem to be going more and more and more. I think the motions will help deal with that, but I think getting people to talk and you know, if you're a judge and you look at some of this stuff and you're like, yeah, you know, you guys are being petty or you're not being professional. After 3 or 4 of these sessions, you're going to start going, wait a second, I don't want to be that guy that's getting the brunt of this. Let me cooperate. Let me work on things. And I think that will raise the bar of our practice as far as getting the events moving more. But
Yeah, because the idea used to be, well, just pick up the phone, right? That was always the argument of everyone in our practice is, why don't you just pick up the phone, guys, and talk to each other? And that sounds like a really good idea. But how many times has it been like, why are they calling me? That would have been solved in an email, or just,
Right.
you know, I'm not picking up the phone, it's Diana, like, no, you know. So, and listen, I get it. So I think forced communication vis-a-vis a motion calendar type concept is really smart because, you know, it's like we're saying, a lot of these things can be resolved. A conversation typically will resolve so many things, and none of us want to go in front of our judge that we're later going to try our case in front of and just, you know, get scolded or be told, why are you guys in front of me over this, you know, and that those little kind of petty things that become big can be very easily resolved.
And circling back, how you indicated you want to get the benefits as fast as you can sometimes for your clients.
not sometimes.
Well, all the time,
Always.
true. In light of that, is there other methods to try to get things in front of the judge faster, like a motion for bifurcation? Is that an aspect that you guys do?
Yes, yeah, that's a good point. I think a motion for bifurcation is great on issues like going and coming or whatever, where a lot of these other benefits will resolve themselves down the road if we can just get past the, hey, let's open the door or let's close the door. Because once we get in the door, it's, you know, we're all fairly professional. We can kind of figure this out. And I think bifurcation is very important towards doing that. Now, you know, obviously different judges throughout the state have a different perspective on things and whatnot, but I think those tools are underutilized. And I think that, you know, there's some concern, some judges are concerned, wait a second, if I bifurcate this, I may not be able to get the second hearing in the same 210-day time span, which seems kind of odd, but it happens from time to time. So I think, again, if the parties can work together and say, you know what, let's streamline this, let's deal with, you know, those of us who have been doing this long enough can look and say, here's sort of a dispositive issue in a case. Let's try and knock the disposition out, and then the rest of that stuff sort of flows.
Yeah, I mean, where do we see the big cases right now? It's all coverage.
Yeah.
I mean, the big conversation, the big, you know, it was MCC for a really long time, and then MCC was codified, and now it's arising out of, you know, it's all coverage. It all comes down to, is there coverage? So I feel that, you know, workers' comp is heading more towards the direction of, you know, the quasi-DEC actions, right? Those of us who do personal injury or who do some sort of civil practice, DEC actions to determine coverage are a very common thing that we'll do, you know, on a case where we don't want to delve into all the costs and all the time that it will take for our clients to determine if there's coverage. I don't have to do an IME. I don't have to have my clients spend that money. So can we get a DEC action bifurcated compensability hearing on an expedited basis, because the parties don't need those same kinds of things that we would need in a full trial. So I think that's a great direction to head in.
What I was going to say, and to alleviate the perception that you have that it all has to be done inside the 210 and the perception that some judges are concerned about, would you recommend then to the claimant's bar to get that motion to bifurcate in front of them as soon as possible?
Yeah,
If you know the employer-employee issue is on the notice of denial, for example, or the first response to the petition, get it out there.
Yes and no. And the yes is, it sounds great on paper. The no is, if you can't get your discovery, then I don't want to have my hearing in 30 days when I'm going to need 100 days more to conduct my discovery because I can't get my deposition. So it's got to be each case specific, because if I need 3 fact witnesses and a corporate rep depot to get to the point where we're able to deal with this issue, and I've got a defense attorney going, hey, let's get this show on the road, and judge, you're holding up my docket, let's move, but you've got to be able to conduct your discovery. So it has to be a balancing act between the facts of each case, but ideally, the sooner the better.
Do you use, Amie, like the 60Q rule motion to expedite discovery? Do you bring that in front of the judge in a situation like that? I
have not. I've not used a motion to expedite discovery. For the most part, our discovery for our cases we both respond timely most of the time. I do a motion to compel. I do the 10-day letter, motion to compel, and then I usually wait a week before I file it. And often after it's filed, I get the response before we have any kind of hearing. So I've not used.
Wow, you're special.
Wow, I'm moving to Jacksonville.
Exactly.
Amie
So-
will be
We're
giving
full.
out her cards.
We're not from
for
Jacksonville.
everybody.
What I find is I get a response after the extenuated circumstances of time, and then that response is deficient, and then I have to file another motion to compel better answers. So yeah, Amie, I'm coming to Jacksonville.
Absolutely.
Again, we're full.
Amie, from an appellate perspective, going back to arising out of, is your focus different when analyzing the arising out of if you have a work-caused injury versus a workplace accident?
Yeah, absolutely. From an appellate, but from both sides, really, from a trial perspective and from an appellate perspective. Kind of the shoelace example that Diana gave, there's a time where it would never cross my mind, okay, were you doing your job at the time that you were injured? Yes. Were you performing your work duties? Yes. Okay, great. Let's move on to what was your average weekly wage? What was, but now we have to stop and think about what is the definition of arising out of. And from an appellate perspective, where I'm struggling as a practitioner, is whether that determination is a legal determination or a factual determination that requires the analysis be, the JCC is saying this arose out of employment because of these facts versus this arose out of employment because, this case says arising out of applies in this circumstance, where it becomes a question of law and applying the cases to the individual facts. And so it absolutely impacts my analysis when I am approached about an appeal. What are we looking at? What was the judge's rationale? Most of the time, if I'm being approached, it's because the claimant did not prevail. And so why did the judge say this did not arise out of? And was it because of a legal conclusion that the judge made, or was it a factual conclusion that the judge made? And how do we move beyond a competent substantial evidence burden versus a de novo review of what is the definition of arising out of? And I struggle with that today because of the latest case law that comes out of the court.
And so obviously you've met with your client, you've figured out statute of limitations, you've figured out arising out of, and you're now moving forward and wanting to prosecute these claims. So now, Diana, in a workers' comp, medical opinions are necessary, obviously. Would you agree that a doctor's deposition is seen by many as your trial, your case in chief?
Yes.
And if so, how do you prepare for and take these doctor's depos?
Yes, and I mean, evidence gathering has always been clearly, as attorneys, the primary focus of our practices, right? But in this kind of newer world of these new cases that we're seeing, discovery, early, quickly, and in the best way possible is really, really important. So the deposition of the doctor is essentially your trial. That's where you try your case. Being very, very prepared for that deposition is really important because that's ultimately, especially when you're dealing with medical issues, obviously, but indemnity issues, right? We need to have a doctor's opinion on basically everything we do, with the exception of coverage. So on those cases, that's your trial. That's what the judge is looking at to determine the ultimate decision on this case. So the key, I think, would be just to make sure that you're taking that very seriously. We do this every day. So it's easy to fall into, myself certainly included, it's easy to fall into the, kind of, oh, we've been here before. Hey, I just saw this doctor on another deposition a couple of months ago. Maybe we're friendly. Maybe we've seen each other outside. And it's easy to fall into just a laissez-faire attitude towards the deposition. But at the end of the day, we obviously represent the client. And we have a judge who's going to look at what we're saying. Our words are very powerful, and making conscious decisions as to what you're going to ask, having your outline really clear in front of you, and knowing these are the 5 points I need to prove. So I have it in front of me, and I'm like, did I talk about this? Yeah. So yeah,
I'm
make
sure
you
she's
have
got a
your
checklist or an Excel spreadsheet somewhere.
spreadsheet.
And an app for the phone that comes along with it.
And I always hear from attorneys, you place the tone as a reader in depositions, and I've actually received some recently. So Ken, I have a question for you. What are the advantages and disadvantages of maybe doing a recorded video deposition of either doctors, claimants, adjusters, any of them?
I think video depots are effective. It's with DOA, sometimes it's harder to get them uploaded and get them into evidence, but I
get the flash drives.
Yeah, I think it's a very effective tool, especially when you're dealing with credibility issues, or you're dealing with sort of, sarcasm doesn't sell on a transcript, so we need a video for that. But I think it's important that...
Is that for yourself or the person who...
Oh, no, that's for me.
Okay, I was just wondering.
Definitely
Okay.
for me. But with regard to videos, I've been using this more and more with my depositions. In circuit court, I videotape every single deposition because it's important. But the difference between comp and circuit is, in circuit, you're taking a deposition, a discovery deposition, and then you're going to basically designate certain portions of that, and you're going to play them in your case in chief. In comp, like Diana said, we're only getting one case in chief. That's the doctor's depot. And oftentimes we're flying by the seat of our pants because the carrier has had 17 conferences with this doctor and exchanged 42 letters, and the doctor's office isn't exactly cooperative in getting us information or doing different things. So we're a lot of times going into depositions not blind, but we're going into depositions handcuffed. And so we have to be able to even be more prepared and think on our feet and be able to counter those points, because I know that we have to put enough meat on the bones for the judge to be able to see what's the rationale, not just the conclusion, oh yeah, major contributing cause of that or no major contributing cause of that, but what's the rationale, especially as we delve more and more into these complexities that the appellate court and whatnot seems to sort of help us create in that landscape, which is, again, turning the ordinary into the extraordinary, the moving target of the law. And so we really have to be extra prepared, and we really have to be prepared to delve into the oddball stuff that's thrown at us. And likewise, I think the same thing sort of proceeds with objections. When we're objecting in our transcripts, I think, again, when we're at our final hearing, at least from the claimant standpoint, obviously it's judge specific, but I think we really need to emphasize and say, Judge, I really want you to address the following objections in this transcript, because I want to make sure they're not waived. I want to make sure they're not ignored. And I want to make sure, again, that's important. And some of that deals with, oh, do we need the motion in limine? And some of it deals with just, hey, is this hearsay or is it not? Is this important? Is it not? And I think a lot of that is, potentially extremely relevant when it comes to proving our case.
Well, and you've obviously have indicated your concerns on the motion in limine.
Yeah.
But I know when we were discussing it, Amie, you indicated you like the motion in limine.
Absolutely. I find that it's a good way to get through the weeds of the evidence before we get to the meat of the argument. And so I appreciate, again, a chart of all of the objections in the depositions listed, page line, what the objection was, what was the physician or adjuster, whoever was testifying, what was the substance. And depending on the quantity of those objections, I will attach that as an exhibit to the motion in limine, so that I find I can present it in a logical manner, and then also so that the judge can easily see, okay, this is a hearsay objection on page 5, and am I going to sustain it? Am I going to overrule it? Because it does matter, especially if there is going to be an appeal on the issue in the Q rules. If you do not have your judge rule on an objection on admissibility, it is considered overruled. And so it is part of the record, even if it is clear hearsay, it is part of the record. So I appreciate motions in limine. I think it streamlines the practice. And I do have judges who say I'm not going to address the motion in limine until the final hearing, and that's fine. I don't need an order. I just want it to be organized in a way that when I'm there with my client, I'm not trying to figure out what I objected to and when, and I can focus on what my client needs to tell the judge to get the point across, and what areas of the law that I need to hit in order to prevail for his or her best interest.
It also tells us you have a lot of free time.
Look, obviously Amie is superior in what she does. The average claimant's attorney, who's trying to just juggle all these, and here's what's truly.
I have an excellent law partner.
Here's the great part of all of this is, that we're supposed to do all of these things. And ideally, obviously, that's the ideal, right? That's the perfect. We should have all of our discovery ducks in a row. We should have all of but we have to do it in like 15 minutes. You get 15 minutes before you have to try this case. Obviously, I'm exaggerating, but the point is, we have to be these really, really skilled, good attorneys trying all of these complex issues that have arisen in the world of workers' compensation. And we have to do it in an extraordinarily truncated time frame. So I want to say to every workers' compensation attorney in this room, we're pretty darn amazing, okay? How many times have somebody said, oh, you do work comp? Oh, yeah, that's,
Well, and I was going to
Get out of here.
I was going to lead me to the next
That
portion.
leads me to my next
We're awesome.
session.
So you've done a
it away,
phenomenal
Ken.
job, and you've gotten benefits for your client, whether it's inside 30 days of the petition, or you didn't have to file a petition, or you did and you secured a benefit. And there's obviously different methods of getting fees. There's employer carrier paid fees. There's fees being paid by the claimant because you obtain benefits timely. And there's obviously benefits from the claimant from a settlement.
Right. and this is a topic that's very near and dear to my
And
heart.
I'm just going to open the floor to Ken, because he's going to go on his diatribe.
That's right. So I mean, obviously, I think there's a perception in workers' compensation, and that perception is we are the redheaded bastard stepchildren to real lawyers. And I think that's a huge problem, because I think as a bar, and you heard Judge Thomas talk about this before, we have probably a set of laws that is extremely complex. It's ever-changing. It's a much more complex, in my opinion, than a negligence-based system. We're moving a lot faster. We have time obligations. We have increased burdens of proof. We have all of these affirmative defense and avoidances. We have it's an extremely complex area of law, and I think we undersell ourselves as a bar in general. I think the claimants bar, we've been so used to dealing with for a zillion years the statutory scheme of attorney's fees, and therefore people don't want to get into comp because it's just comp. It's this lowly area of law, and I think that we as a practice need to raise that perception. I think our judges are vastly superior to most other areas of law.
Thank you for the love.
And I think we need to we need to recognize that. And I think the defense bar, the same thing. I think we as a whole need to raise our perception of our own practice, because it's super important, because part of that perception is we're selling ourselves short. We're not looking at the economic reality of our practices. We're not looking at the economic reality of inflation. We're not looking at the economic reality of anything. I think the defense bar is probably selling themselves short with the hourly rates that they're charging. I think the claimants bar, certainly when we look at economics, I think there's some artificial constraints there. And I don't think it's subjective. I think it's objective. I mean, obviously we look at the world around us and we see the increased cost of everything. Yeah, rent this room in 2000 and rent this room today, you're going to pay a hell of a lot more for this. So let's look at objectively. Let's look at the numbers.
Well, so how do you prove those hourly fees?
Well,
How do you bring that to
So
front of it?
let's talk about that. Let's use the maximum compensation rate. So that's the average of statewide salaries over the years, and it's an objective measure because it's put forth by Tallahassee every year, and it's the basis that our claimants are compensated by, and that's to account for inflation and account for the diminution in the value of the dollar. So let's look at that. From the year 2000 until 2024, the max comp rate has risen from $541 a week to $1,260 a week. That's a 132% increase. Attorney's fees have not risen. And let's talk about that further. Let's talk about hourly rates, and let's talk about some of that stuff. Well, Judge Langham was a firm advocate of that back in 2017 when he was citing studies saying, Judge, you deserve a raise because, quite honestly, your salaries and your hourly rates are not keeping pace with inflation. It's unfair. It's unduly burdensome. It's egregious. It's preposterous. It's outrageous, as they say.
Any more synonyms?
No.
Okay.
Where's my thesaurus?
That was my Seinfeld. So now let's talk about that. In the year 2000, for example, a $200 hourly rate in today's dollars would be $464. $250 would be $580. $300 in 2000 would be $696, and $350 an hour in 2000 is $762. So objectively speaking, just counting for inflation using the max comp rate tables, we see that to keep claimants, attorneys, or to keep whatever in a range of, say, $250 to $400 an hour, that's artificially constraining the economic reality of our practice. And it's undervaluing our services. It's undervaluing what we bring to the table. It's undervaluing the level of our practice. It's undervaluing the complexity of this law. It's undervaluing our skills. And it's furthering the perception that workers' comp lawyers are just these bastard red-headed stepchildren of real lawyers. And I think that's a huge miscarriage of justice. I think it's a huge problem.
So how do you bring that information? What is your strategy, tactics in bringing that information in front of a judge at a hearing?
So I, for example, I attach to my verified petition, I attach the max comp rate tables. I attach testimony from an economist. I look at the numbers. I look at Judge Langham's blog. I look at the economic reality of it. I look at the 2022 economic study where the average non-contingent lawyer is getting well north of $400 for no risk, for no contingent risk, for not having to deal with the arising out of coverage issues, for not having to deal with the increased burden of major contributing cause, for not having to deal with the ever-changing landscape of workers' compensation, and for not having to be on a rocket docket where in circuit court I'm getting 24 months to get my case to trial, and the reality of it is it's oftentimes longer than that, when I've got to be in trial prepared with a higher burden of proof at 210 days than a less complex case that gets multiple discovery depositions, multiple hits at the bat, and in an extremely complex landscape. So I think we as the workers' compensation bar, quite honestly, are allowing the perpetuation of this we are inferior perspective, and I think it's wrong. I think it's wrong from the claimant's bar. I think it's wrong from the defense bar. I think it's wrong from the judiciary. We need to elevate our perception because we are, quite honestly, I'm going to say this, we're better freaking lawyers.
And Ken has volunteered to be the lobbyist. Just want to let you
Well,
know.
and so obviously, look, that's the gripe, right? And it's accurate, and it's valid, and it's 100% right on. But it's one of the Lee engineering factors. Right. Did you guys remember that factors has an S at the end of it? Because there's more than one factor that the court needs to consider. So that was my gripe. But, you know, the reality is that, yes, he's talking about one very important factor of Lee engineering that we need to focus on when we are presenting our affidavits to the court. You know, putting as much information as you can into an affidavit from a practical perspective is important. I know we said something to Judge Sancerni like, oh, do you guys want to see like, you know, a 40-page? And she's like, yeah, I don't care if it's 100 pages.
If it takes 40 pages to give
You know,
me the information,
Right.
I want it. Because if not, you know what happens, and I'm sure there's a lot of attorneys here that can attest to it. When I don't get that, either you might get a denial or you might get a hearing. And then you come into the hearing and you're like, well, Judge, I had to do this. And I'm like, where was that in the affidavit? So all you're doing is prolonging the time.
I think
So I'm
our
glad
judges,
you bring that
our
up.
judges just want you to tell them why this is an appropriate fee. And if you are able to justify it appropriately and provide them the evidence, I don't think that there's a judge who's going to go out of their way to say, no, you gave me everything I needed. You laid it out in front of me. But, you know, it is important that it is a multifactorial process. And we have to ensure that when we are presenting this to our judiciary, that we are presenting all of these factors in the light most favorable to our client and to our practice, because the reality is there should not be a focus on any one factor more than another. So while it's very important that we lay out the hourly fee stuff, it's very important that the courts are considering everything. You know, we were talking in preparation for this about the contingency nature of our practice, and the response, the correct response, and the response we hear a lot from Judge Sancerni was, well, yeah, but there's employer carrier paid fees in workers' comp, right? So it's a hybrid contingency practice. And so when we were all chatting, for those of us, myself and Ken, who also have a personal injury practice or a liability practice, we said, well, wait, you know, that hybrid contingency is kind of true in every area of practice, right? So in personal injury, there's offers of judgment. If you make an offer of judgment and you're successful at, you get more than the offer of judgment or the proposal for settlement, depending what side you're on, you are entitled to a prevailing party fee. So
Which
that's
oftentimes comes with a rate of $1,000 an hour or a multiplier, as opposed to whatnot. So again, hourly rate is not the end-all be-all. It should not be the focus. We should all weigh the entirety of the Lee engineering factors. There's been a lot of, at least in my jaded experience of life, there's been a lot of too much overemphasis on hourly rate versus let's look at all the factors. And I think the Rudolph case did a good job of pointing that out, not necessarily in the context of different aspects, but again, let's look at Lee engineering and let's weigh all of the factors. Let's go into that. And I think it's important that we as claimants document that and we present the evidence, because ultimately, you know, we're the ones that have the burden and we're the ones that are carrying the ball. So I think it's important from a claimant's bar that we put in all of these factors and that we put them in with detail.
I was going to say, so your recommendation really is don't sell yourself short.
I agree. I think we've all, as a general practice, sold ourselves short, and I'm here to advocate today that should change.
Amie?
I know we're out of time, so I won't say very much, but I do want to add very quickly that from an appellate perspective, I talk to a lot of non-comp. Everyone in here is comp. maybe other areas too, but comp. And I talked to a lot of non-comp appellate lawyers, and they will not touch claimant appellate issues because of the contingent nature and because of the hourly rate. Why would they take a contingent appeal and get, 400, 500 when they can get paid 700 without it even being contingent and without having the higher burdens and the CSE and all of those things? And so from an appellate perspective, I literally have people say to me, I don't know why you do that because you do not get paid enough to do what you do.
And I get asked that every day, like, why the hell are you wasting your time with workers' comp?
And I say I like charts. No.
Yeah. And Judge Thomas said, hey, why first DCA? Why are they the court that's handling workers' compensation? It's too complex. It's too complex. So why, again, if it's complex, that there's only one court and there's the complaint to state like every other. Well, why are we holding ourselves, constraining ourselves when the economic of it is we should not be constraining anything. That's all I think.
And if anybody is technologically savvy, Amie would like to talk to you about creating an app so that she can make money off of all her Excel spreadsheets. Thank you, everyone.
Thank you.